This Honorable Court of Criminal Appeals is now in session.
Welcome, everyone, to the final case of the call of the February docket here in Nashville, Tennessee, February the 10th. We thank you for being here. I want to thank Supreme Court Clerk Jim Hibner and his staff, as well as the staff at the AOC, for their hard work in getting us able to have oral arguments in this fashion, in this format. We appreciate the lawyers and the extra work they had to do as well to be prepared to be here today. Mr. Clerk, I'd ask that you go ahead and call the next case, and I'll continue to talk to the lawyers after that.
State of Tennessee versus Andrew G. Walsh.
Thank you very much. The panel that will be hearing your case today, to my right and your left, I guess, would be Judge Bobby Holloway from Columbia, Tennessee. And on to my left and your right, I take it, from Nashville, Tennessee, Judge Robert Wiedemeyer. I'm John Everett Williams from Huntingdon, Carroll County, Tennessee, and we're delighted you're with us today. Each side is given 20 minutes to argue before us. The appellant may reserve time for rebuttal. And ma'am, you should do that upon introducing yourself to the court. And you may do that now. Your time starts now.
Thank you, Your Honor. My name is Erin Coleman, and I am the attorney for Mr. Andrew G. Walsh. And I would like to reserve 5 minutes for my rebuttal.
Yes.
I would like. Thank you. I would like to start out that there are 3 issues in this case, and they're all within the sentencing guidelines. The first, which the state declares as moot, is whether or not the jail, whether or not my client should have been given probation rather than jail time on his 11 months and 29 day sentence. The state says that this is moot because my client has already been released from jail. He was released on a motion to suspend his sentence and be placed on probation in May of 2020 due to the COVID outbreak in the jails. Even though the trial judge had asked or had stated that he must serve the full 11 months and 29 days. I argue that that this, in fact, is not a moot issue because the jail, because of the other issues that we'll be discussing today, such as eligibility for judicial diversion. As you know, judicial diversion is not readily available to those who have served more than 30 days in jail, and so therefore it is imperative that this court find that the trial judge abused his discretion in mandating that my client serve an 11-month and 29-day sentence. And if finding that, then you can then determine whether or not my client is still eligible for diversion, which we hope that you will find. In looking at whether or not someone should be allowed to be on probation, you're looking at whether there is the nature of the crime, the probability that someone would actually be able to complete probation, and whether or not being allowed on probation would deplete the seriousness of the crime. Through the sentencing hearing, we found that you can hear that the defendant himself was an upstanding citizen up until the moment that this case kind of took shape, and that within his sentencing hearing, he in fact was very sorry and apologetic for the harm that he caused both to the victim and to his family. He took great responsibility for his actions, and the influence of those actions upon the rest of his life. And he understood through the sentencing hearing, you can see, which is part of the transcript, that he in fact understood the seriousness of his crime. He was 34 years old at the time of the crime, and had no prior history. In fact, was college educated. Comes from a great family, a great and supportive family. His father, in fact, spoke at the sentencing hearing on his behalf. And so we would argue that he had a great probability of success in completing probation, and that because of his understanding of the seriousness of the crime and his taking personal responsibility for his actions and his willingness and wanting to apologize to the victims and his family for all of his actions, the being allowed on probation would not in any way have depleted the seriousness of the crime. So I would argue that the judge did actually go beyond his discretion and did not properly look at all of the elements that he was supposed to look at when determining whether or not a person should be allowed to successfully complete probation versus being sentenced to time in jail. And again, I would argue that this is actually not moot because this is a very important decision to be made by your honors before moving on to whether or not my client should have been given the opportunity to divert his conviction. In looking at that next segment of our appeal, we would also argue that the judge did abuse his discretion when mandating that my client could not divert the judgment after successful completion of the sentence. When looking at the factors in determining whether or not someone should be allowed to have diversion, you're looking at whether or not the defendant is amenable to correcting his behavior. We would argue that through the sentencing hearing, you can see that he is in the utmost respect amenable to correcting the behavior. Throughout the pre-trial and pre-sentencing time period, he went on his own accord and received therapy for all of the sexual and porn addiction that he might be having, and which led him to making the decisions he did in respect to this case. He also has no record. You're supposed to look at the defendant's record, of which he has none. Looking at his social history, as I've said, he has a strong family, many siblings who live in the area, and many friends. He also has a stellar work history. He was a he was a, oh, I'm so sorry, geez, I don't know how to turn this off and keep going. Okay, fine. I know, I'm so sorry. I'm quite nervous. And my phone rings through my computer. I'm so sorry, and I have to keep the voice on, volume on for you to hear me. He had a great job as a fitness instructor and had a great job history before these instances occurred. Additionally, mentally and physically, he was bettering himself throughout the duration of the pretrial time. The factors that the only factors that the court seemed to consider in their ruling on whether or not my client could have diversion was looking at the circumstances of the offense. And we would argue that the judge really leaned on the idea that my client planned on taking these videos of his roommate, and that in itself was egregious in nature. And in fact, I think some people would find that. But the planning of taking unlawful and unwanted photography is in fact one of the main elements of the crime of unlawful photography, which he agreed to plead to. And so there's an argument to be said that it's in fact double jeopardy in a way to consider just those factors and just the idea of planning unlawful and unwanted photography as the only reason for a person to be given no diversion status. And in fact, that is really what the judge leaned on in a tremendous way in the sentencing hearing and in his decision-making factors. Additionally, the judge seemed to be overly concerned with the deterrence value to the defendant and to the public in never allowing this again, and that not allowing my client to have his diversion status would protect the public in the future. Although in a highly contested and highly visible offense in which TV stations and reporters are in the courthouse recording and reporting on the outcome, that deterrence argument might hold bar. But this was not one of those cases. This is not a case in which there was a great deal of public view, if any public view, as to what was occurring. This is one of those cases that was just run-of-the-mill, was a run-of-the-mill case in which, yes, the outcome would be public record, but it wasn't recorded or reported upon within a TV station or a newspaper.
Was there any proof in the record for the need for deterrence? Did the state put on any proof at the sentencing hearing that this type of crime had been a problem in the past or anything like that?
No, there is no there was no proof in the record that the state put on that this is an overarching issue within our community, and he had never had this problem in the past. Additionally, when the detective confiscated his computer, which these videos were placed upon, the detective stated in the sentencing hearing that no other videos were found of recordings of anyone else. And in fact, additionally, to even further the point of that there was no need of community deterrence, there was no indication and no investigations found that he had placed these videos on any internet. He had never dispersed them, even through an email to himself.
Let's forget deterrence for a moment. Was there any other factor other than the seriousness of the offense that the judge denied probation on?
No, those would be the only two. In my reading through of the hearing transcript my memory of the actual sentencing hearing, since I did do the sentencing hearing, he did not indicate any other reason for not placing him on probation and for giving him the maximum sentence in jail, for giving him no diversion, and for placing him on the sex offender registry, other than deterrence for future crimes. And to really, the trial judge made an amazing may not be the word, but he really made a strong point in wanting this to be a case in which showed that this was the wrong thing to do. And that is not in itself a reason to ruin someone's life. And I have about 3 or 4 minutes left. So I would like to move on to the sex offender registry and why placing someone on the sex offender registry for a crime of this sense is an abuse of power and excessive in the utmost extent. I think we all understand that like probation, the sex offender being placed on the sex offender registry is not necessarily a sentence, but it is an additional component of someone's sentence. And the being placed on the sex offender registry itself is an extreme burden to someone in moving on with their life and actually overcoming the implications of their actions. The burden of a sex offender registry occupant is you can't work in certain places, live in certain places. You have to register and keep in contact with the registry at all times, and any violation itself puts you in the way of becoming a felon. And my client at this point in time is not a felon. He is only convicted of 2 misdemeanors. So in fact, any violation of the sex offender registry would in fact would make him a felon, because it's an e-felony to violate the sex offender registry. So
You think one of these young girls were underage?
I understand that.
You think he ought to be around underage girls?
Well, I understand that, Your Honor, and as the mother of two young girls, I completely appreciate where you're coming from. But I would argue that, as it was shown in the sentencing hearing and within the record of the case, the 16-year-old was not his intended was not his intended victim per se. He was very helpful to the detectives, very forthcoming, to his detriment, to be quite honest, in that he was only wanting to take videos of the adult who was living with him. He never, in fact, intended to take videos of the 16-year-old, and there was never any evidence put into place that he really even viewed those videos. In fact, during the sentencing hearing, he said once he realized who was in the video, I think he said that he deleted those of the 16-year-olds. He didn't even watch them. So I understand and I appreciate the abhorrence of videoing young girls. But in this particular case, that was really not even anything that the trial court really focused on. They really focused on the deterrence action. And I think, making someone I'm blanking on how I want to describe this, but making them the role model of what you shouldn't do, is it's okay for, if these were very serious offenses. This was a misdemeanor, and to place someone on the sex offender registry for 10 years, and to hinder their ability to move on, and the possibility of becoming a felon just because if they were to violate these really hard to follow rules, I think is quite an overreach in comparison to what actually occurred.
All right, let's hear what the state has to say. And you have 5 minutes for both.
Thank you.
Your Honors, and may it please the court, Cody Brandon for the state of Tennessee. We respectfully request that this court affirm the judgments of the trial court. First, Your Honors, the appeal of the denial of probation is moot. Defendant was granted the relief that he asked for before briefing in this case and after filing of the notice of appeal, I think in April of last year. And because he cannot obtain relief from this court in the form of a grant of probation or a remand for the trial court to grant probation, this case, at least with respect to that issue, no longer presents a genuine case or controversy that this court needs to decide. So this court should find that the appeal of the denial of probation is moot.
But if it's not moot, what's your argument?
If it's not moot, Your Honor, the trial court didn't abuse its discretion in denying probation. That decision was supported both by deterrence and the circumstances of the offenses. And
was there any proof in the record on the need for deterrence?
There was not proof in the record about the need for deterrence within the community. As contemplated, I think Your Honor is referencing the State versus Hooper standard for need for deterrence. But because deterrence wasn't the only factor considered here for denying probation, the seriousness of the offense was also considered. The state can.
Let's say that there's no need for deterrence proven, and therefore they can't consider that, leaving only the seriousness of the offense as a ground to deny probation. What's the state's position as to that?
The state's position is that this court should follow the standards set forth in State versus Ciapagna, that when a trial court considers the seriousness of the offense along with the deterrent effect, that there's no elevated need for that proof of deterrence when there's two factors. The Hooper standard applies only when deterrence is the sole factor that's relied on. So because the trial court relied on a mix of factors here and not solely deterrence, the state didn't have any responsibility to comply with Hooper and present that heightened burden of deterrence when.
Well, if the seriousness seriousness of the defense is determined by the level of the offense. In other words, from a Class C felony to a Class A felony, or from a Class C misdemeanor to a Class A misdemeanor. This is a fairly minor offense. I'm not saying it's not a bad offense in the nature of the classification system. Why would the seriousness of this Class A misdemeanor be enough in and of itself to deny diversion, deny probation?
Because of the facts of this case, Your Honor, it is a misdemeanor crime, but the facts of this case, as found by the trial court, were egregious. Defendant didn't just take a picture or a couple pictures of his victims. He engaged in a sustained clandestine effort to photograph at least one of his victims, and then knew that the hidden camera was in a position to take photographs of the underage victim and didn't intervene to stop those pictures from being taken. The defendant planned these recordings, hid a camera in a USB device that he gave to his victim, his target, that was later borrowed by the 16-year-old, and then again engaged in sustained efforts to collect videos from the hidden camera in the USB, replace the SD card into the camera, and this was an ongoing offense that was, as the trial court correctly found, especially egregious and supported the denial of probation. But again, Your Honors, the state thinks that you don't need to reach that issue because the appeal of the denial is moot. But
General, there used to be a case involving our review of misdemeanor sentences that virtually said we don't look at them as hard as we do felony sentences. And the reason being is felony sentences, I can't think of the name of the case right now, but it was a Supreme Court case. And it was, if the judge said the DUI was 11 months and 29 days, we really didn't look at it as much as we used to on the other type of cases, much like a bias situation. We've got bias, and that has given judges, I think, a lot of unfettered discretion to do what they wish to do, even if they get a factor wrong. We don't change it. Are you aware of that older case I'm talking about, where it says we don't look at misdemeanor cases as hard as we do felony cases?
That does ring a bell, Your Honor, but I'm not sure of the name of the case or its application here. I'd have to check before making any arguments. But we think that, Your Honor, even applying the regular abuse of a discretion standard that's applicable here without affording any extra deference, that the trial court clearly didn't abuse its discretion. Turning to the denial of diversion, that was also, again, well within the trial court's discretion. Diversion is a form of legislative largesse that is left to the discretion of the trial court. And here, the trial court discussed the Parker and electroplating factors and weighed those on the record and found that defendant should not get diversion. Most importantly, the trial court found, again, that the circumstances of the offense were egregious, as I just discussed. This was a sustained clandestine effort by the defendant, and the trial court weighed that factor heavily against the defendant. The trial court looked at the defendant's criminal record and found that he had no criminal record and that his social history was not predictive of these offenses. And the trial court did not find any issues with defendant's physical health, but trial court was concerned about defendant's mental health in that he was still viewing pornography and had not talked with his therapist about that as part of those efforts that he was undertaking to better himself before sentencing. He still had not addressed this pornography issue with his therapist. The trial court also found, again, in the Parker and electroplating factors, that granting or denying diversion would have a deterrent effect both on the defendant and the general public from violating privacy of women with these hidden cameras. And the trial court repeatedly emphasized the ends of justice in its decision, stating its intent to set a fair punishment in weighing these diversion factors and account for defendant's risk to the community. The only Parker and electroplating factor that the trial court didn't explicitly weigh on the record was the amenability to correction. But under this court's precedent, the trial court's findings about the defendant's record, social history, and mental and physical health can be an implicit finding of the amenability to correction. But even if the trial court never made that implicit finding, the trial court doesn't have to discuss every Parker and electroplating factor, as long as it's clear that it was following the Parker and electroplating analysis, which it is clear from the record here. So the trial court did not abuse its discretion in denying diversion in this case. The order to register as a sex offender was, again, a discretionary decision, and that exercise of discretion is accompanied by a presumption of reasonableness, which this court should not overturn. The statute directs the trial court to make a decision on registering as a sex offender for unlawful photography based on the circumstances of the offenses. That's a guiding factor, and it's not exclusive. This court, in a very similar statute, addressed in State versus Broderick, held that trial courts could also consider other relevant factors. The trial court here followed the statute and the precedent in Broderick by weighing the circumstances of the offenses, which the trial court found were egregious, and the risk that defendant posed to his new community. Defendant moved to Texas after committing these offenses, and the trial court was concerned that a community unfamiliar with his offenses against these women would have no protection against future conduct if he was not required to register as a sex offender. And that weighed into the decision, the discretionary decision to order registry as a sex offender. I think
the registration requirement for this offense, was that 10 years and then he can be taken off if the TBI decides to take him off? Is that the length of his sex offender registration?
I believe it's 10 years, Your Honor. Yes.
And then that's not automatic. He's got to apply and be approved by the TBI that says he can get off, correct?
I think there's a process for applying for termination of registration, and then there's also a process for review of those decisions by the TBI in Chancery Court, Your Honor. And just very quickly, defendant cites the Hooper standard in the denial or in the order to register as a sex offender in her brief. Again, Hooper is applicable to probation determinations, not the discretionary decision to order registry as a sex offender. And even if the Hooper standard was applicable, just as with the probation decision, deterrence was not the only factor considered here. So the Hooper heightened requirement of proof of a need for deterrence in the community wouldn't apply because other factors were considered, even if it did apply to the decision to order defendant to register as a sex offender. So for those reasons, Your Honors, unless the court has any further questions, we'd ask that this court affirm the judgments of the trial court.
Thank you very much. Ms. Coleman, you have 5 minutes.
Thank you, Your Honor. To rebut a few of the state's points, we would argue that even if Hooper does not apply, it is still incredibly important that the trial court looks at all 7 elements when it comes to determining the appropriateness of putting someone on probation versus committing them to incarceration. And it is quite obvious. And I would also argue that those elements should be weighed equally. There is no case law, nor does the statute state that one element should be heavily outweighed over all the others. And it is quite obvious through the sentencing hearing transcript that that is exactly what the trial judge did. He only looked at the deterrence capabilities and the seriousness of the crime. He did not, and there was no proof. I would agree that there was no proof put on the state that there was a need for actual community deterrence in this case. So in fact, he was only looking at the seriousness of the crime. He did not equally weigh any of the other 5 factors that he should have weighed. And that is a complete abuse of discretion to not weigh these factors equally, because the court system and the state legislature have asked us to weigh things equally. There is no, as I've stated, there's no cases that state otherwise. Additionally, I don't know of the case that your honor Judge Williams was referring to, where we look at misdemeanor cases not as hard as felony cases. But I think that in fact heightens the reason that this going on to the sex offender registry heightens the idea that putting someone on something as serious as a sex offender registry for 10 years when they've only been convicted of a misdemeanor is even more illogical and unreasonable than than otherwise stated.
Well, the legislature said that's appropriate. So am I to infer that you disagree with the legislature's wisdom in that decision?
Your Honor, I think that in this particular, although I think that I agree that the legislature gave it as an option, I think that it is very interesting that they did not make it mandatory. And in fact, as we've seen through this through the state legislature, they are very emphatic in what they believe in, and they do not like to give judges much discretion. They are a legislature that enjoys the word shall, and so I think that it is imperative to look at the reasoning as why they would give a may in this particular situation, especially when it comes to such things as unlawful photography, which could be pornography, especially when it could be minors or adults. And they did not indicate that if it was for a minor, that it must be a shall be on the registry. So I think that in fact states that the legislature did not want the registry to be used as often on this particular crime.
I think there is. I think in regard to that, when they did away with pretrial diversion, there was a feeling that when you got judicial diversion or pretrial diversion, nothing happened, and the public found was very much disgusted about that nothing happened to people that do bad things.
Well, I don't know that I would agree with the idea that nothing happens to people who do bad things. Obviously, judicial diversion is only granted if you successfully complete the sentence for which you have either agreed or been convicted for. And to complete a sentence, whether it be 11 months and 29 days or up to 4 years in a D felony, then that is having to live with and deal with and be punished for the crimes for which you are being judicially diverted. So although I understand what the community might see as not being punished for a crime, the actuality of what happens to a defendant when they are actually able to complete and have their crime diverted, they do have to live with that crime for some time, Your Honor. So I would respectfully disagree with the community in that stance.
Thank you very much. Does that conclude your argument?
And just very, very briefly, Your Honor, as to the sex offender registry, there's no case law as to how it should be looked at, but we would like it to be looked in the same way as probation versus jail time. And in looking at that, there are 3 cases that we cited in our brief: Townsend, Crawford, and Bickford. And I think that you will find in looking at those cases that this honorable court had decided that Townsend was overly sentenced, and that you would find that Mr. Walsh was in the same vein overly sentenced in this case as well, because he is more similar to Mr. Townsend than he was to Mr. Crawford and Mr. Bickford. And so we would ask for you to respectfully allow him to not be on the sex offender registry, allow for his case to be diverted, and for him to be, I guess, allowed on probation, but to be given credit for probation for the entire year. And so it should look as though he never did do the jail time, so that his judicial diversion can be awarded when he completes the probation.
I thank you both for your presentation. You're the case we've been looking for today. It's the last one. So thank you all for participating and waiting. And we'll ask the clerk to come back and adjourn court to the call of the next docket. And we'll ask Nick to be with us after we close out.
Thank you.
This honorable court is now adjourned.
Thank you.